Bloomberg Audio Studios. Podcasts, radio, news.
This is Bloomberg Law.
Employers frequently exploit the weaknesses in the law.
Courts are going to be asking questions about separation of powers.
One by one, Google settled with all of these other plaintiffs.
Interviews with prominent attorneys and Bloomberg legal experts.
Joining me is immigration law expert Leon Fresco, First Amendment law expert Caroline Malik-Corbin,
and analysis of important legal issues, cases, and headlines.
The trial judge may well want to hold a hearing. They have never said this case should never have been brought in the first place.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to the Bloomberg Law Show. I'm Nathan Hager, filling in for June Grasso. On the show today, we focus on the Supreme Court. We'll hear a portion of a special conversation with retired Supreme Court Justice Anthony Kennedy. He sat down with David Rubenstein earlier this year at the 92nd Street Y in Manhattan to discuss his 3 decades on the bench, some of his landmark opinions, and more. That's on the way on the Bloomberg Law Show as we focus on the Supreme Court. But before we hear from a member of the court's past, let's spend some time on some of the major cases that are expected to face the High Court in the new year. Joining me for a look at what to expect from the Supreme Court in 2026 is Harold Krent. He's professor of law at the Chicago-Kent College of Law. Harold, thanks for being with us.
My pleasure, and there's certainly some showstoppers in terms of cases coming up in the next couple of months.
No kidding. And I think probably the one case that Wall Street is certainly waiting for a decision on is one that the High Court already heard about. Of course, that's on President Trump's emergency tariffs. Should we be expecting a decision on that in the next few weeks, do you think?
I don't think it'll be next few weeks. I think it'll be later in the term, but certainly that's critical. But the other critical case for Wall Street has to do with the discharge of a member of the Fed Reserve Board, Lisa Cook. And even in the argument that was just, had a couple of weeks ago, the members of the court suggested that they might deviate from President Trump and say that even though he has the ability to fire heads of independent agencies, he can't fire the head or one of the members of the Fed. So that'll be of great interest to Wall Street as well.
Certainly. Let's talk a little bit more about what we learned from those arguments around the possibility of firing independent agency heads. Do we get some clues there about how the justices could respond to the arguments that are coming up in the Fed Governor Cook case in the next couple of weeks?
Yeah, again, 2 members of the court, Chief Justice Roberts as well as Justice Kavanaugh, suggested that they had some kind of reticence about following the logic of the argument from the FTC case, the Federal Trade Commission case, and to apply it to the Fed. And I'm not sure that it's a coherent distinction, but it's one that the court is exploring. And I think there may be a majority to say that the Fed, because it has some private members, because of its special role in history, might be segregated. I mean, the interesting thing is what else will be segregated from the sweeping ban or sweeping permission for the president to fire at will all members of independent agencies. Maybe adjudicative agencies such as the Merit Systems Protection Board. We don't know, but it looks like the Fed will be one of the exceptions that the court will adhere to.
Are you thinking that we're going to hear arguments around the merits of the case, the argument that President Trump and his administration is putting forward here, these allegations of mortgage fraud that they've been using to say that the president does have cause to fire Governor Cook?
I think they will probably not talk in detail about the mortgage fraud issue, but they will talk about whether or not the president needs cause to fire the Cook, Lisa Cook. I don't think they'll get into the question about what constitutes cause, but I could be wrong. Certainly, there's been a lot of people who have been investigated by the Trump administration who have similar issues, and they seem to be pretty thin when you push on them, but I don't think they're going to get into that particular issue of what constitutes cause for discharge. If they say that you need cause, I think that will be enough of a statement from the court.
Walk us through some of the arguments that we could hear when it comes to the idea of for cause rationale to fire a Fed official. Do you think we're going to get a clear definition from this case about the bar that's set for the Fed when it comes to cause for firing?
Yeah, and the court has been incredibly vague about what constitutes cause or neglect of duties in all of these cases. So it's never really given a really good blueprint about what kind of reasons a president must articulate before they can discharge someone who's protected from discharge except for cause. That has been adjudicated a lot in employee cases. So we know cause means some kind of wrongful conduct on the job. So we don't know if in this case with Lisa Cook, this was something that happened way before she was a director of the Fed. I think the fact that it happened before probably still could give reason to cause. I mean, you could think about someone who's committed a serious crime before they're appointed and only comes to light afterwards. But the court has not articulated what cause means. And I don't think this will be a vehicle that will see it in terms of the timing of the nature of the misconduct, how serious the misconduct must be, how tied it is to their ability to function the job. These are all the questions of what cause might constitute, but I think we're going to have to wait another day before we get a court ruling on that issue.
And how important is this case when it comes to preservation of Federal Reserve independence? Are we going to get a really clear idea around that?
I think we will. And my guess is, again, there'll be a carve out for the Fed, and it won't necessarily be, coherent, but it's something I think that the court wants to take a position on. And, the interesting issue is whether they'll give some kind of hint about whether there are other carve outs or whether this general rule, the fact that Congress cannot protect any kind of agency from the president's plenary removal authority, whether that will be the binding governing rule with only the Fed as a possible exception.
We're speaking with Harold Krent, a professor of constitutional law at the Chicago-Kent College of Law. Harold, let's talk about some of the other cases coming before the High Court in the next month here. We're expecting arguments around the president's efforts to roll back birthright citizenship. This is an issue that's come before the court on a legal question, but I think this is the first time that the justices are actually going to be weighing in on the order itself. Is that right?
Yeah, I mean, the court dealt with birthright citizenship almost 100 years ago or so in the Wong Kim Ark case, holding that someone who was born, not a citizen, born in this country, could basically obtain birthright citizenship. I don't think the court's going to deviate from that in this case. I think it will deal the Trump administration a blow. All the lower courts have gone against President Trump on this issue. So I would predict and think it's quite compelling for the court to hold that the executive order redefining citizenship is inconsistent with the words of the 14th Amendment.
Well, what's the Trump administration's rationale, its reading on the 14th Amendment? What are the arguments against it?
Well, the 14th Amendment reads in pertinent part that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. It seems plain. It seems to cover anybody who's in the United States and who was born there. What the Trump has redefined it to say that they need to be subject to the lawful jurisdiction of the United States. In other words, to put lawful in front of jurisdiction to suggest that people who are here illegally cannot get the benefit of this citizenship clause. I mean, that is a plausible argument if it had been written in the 14th Amendment and if it had been interpreted that way in the past. But the Trump administration is going against history as well as the plain language of the 14th Amendment in making its argument.
Now, this isn't the only immigration-related case, if you want to argue that birthright citizenship is part of the immigration issue that the High Court is going to consider in this term. We're also awaiting arguments on the Trump administration's practice known as asylum metering. Walk us through this, Hal.
Yeah, it actually comes from the first Trump administration. Where there was a rush at the border, and under the immigration laws, everybody who is at our border can apply for asylum, and then they're guaranteed some kind of hearing, which unfortunately usually takes several years before it materializes, and people are waiting around for that hearing. So to neutralize that, the first Trump administration undertook this metering policy, which said that if there was too many people at the border, they simply can't apply for asylum. And then the question is whether that rule is consistent with Congress's statute, which says anybody in the United States can apply for asylum. And the argument there is if you're 2 feet away from the border and you're being held back by agents of the immigration agents, are you therefore not in the United States and therefore cannot apply for asylum? And the lower courts have struck down this policy, but I think it's an open question. I think the Trump administration might win on the narrow ground that if you're 2 feet away from the border, you're 2 feet away from the border, and immigration agents can apply force to prevent somebody from applying for asylum. That's just a guess, but I think Trump administration has a much better chance of succeeding on this than on birthright citizenship.
Interesting. We're also awaiting some arguments on a major case when it comes to mail-in ballots. Walk us through what the court's going to be considering here.
I'm just sort of astonished by this case. We obviously have had the question of mail-in ballots throughout, most of our history as a country. And you know that for a mail-in ballot, whether it's from overseas or from even the states, they may not arrive in time for Election Day because you can't know when Election Day will, you can't know when the mail is going to arrive. So the claim here is that when Congress set a particular Election Day, that it means that all votes must be in on that day to be counted, so we as a one country can know what the result is on that particular day, and so that the 15 states that have mail-in ballots and the 29 states or so that have military mail-in ballots, they have to cut off counting the ballots for any ballot that comes after Election Day. This is it's going against history. It's going against sort of practical understanding, but it will have a major impact in the future upon the role of mail-in ballots in our elections. And if the court holds that Congress's designation of Election Day precludes mail-in ballots, then absent a congressional amendment, the whole notion of mail-in ballots from overseas or from the states will have to be altered significantly. And I'm not sure that that's going to be the best for our country.
Thanks for walking us through what's going to be a very busy second half of the Supreme Court term heading into 2026. That's Harold Krent, professor of law at the Chicago-Kent College of Law. Up next, we hear a special conversation with retired Supreme Court Justice Anthony Kennedy. You're listening to Bloomberg Law. I'm Nathan Hager, in for June Grasso, and this is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Thanks for listening to the Bloomberg Law Show. I'm Nathan Hager, in for June Grasso. Today's show is focused on the Supreme Court. Earlier this year, David Rubenstein got a chance to sit down with someone with decades of experience on the bench, retired Justice Anthony Kennedy. The two spoke at the 92nd Street Y in Manhattan for an extended conversation that covered everything from some of Kennedy's landmark decisions to his thoughts on the rule of law. Let's listen to a portion of that conversation now, starting with Kennedy's decision to write his memoir, Life, Law, and Liberty.
I wanted to write about Sacramento, a small town in the 30s, 40s, 50s, 60s. My children grew up in Sacramento, but they didn't know about those earlier decades, and my grandchildren didn't know Sacramento at all. So it seemed to me interesting to me to write about that time in our culture. Our generation was right after the Great Generation. Right. And the small town, there was a courtesy, there was a professionalism that were simply wonderful. I wanted to write about that. Supreme Court, the first thing many people do is they forget about the Sacramento part. They want to read about the recent cases, so they look. But we wanted to have this for our children and our grandchildren to read. And then, as the writing went on, it seemed to me people were saying that it might be of interest to others. So
for those people that have not been a justice of the Supreme Court, and you were on the court for 30 years, what's the greatest thrill about being on the court, and what's the biggest downside to being on the court?
The biggest thrill is that you have only cases in which the law has been undecided. And you recognize that what you're doing is exploring the law, and you know that after you write what the law is, or what you think it is, there's a whole new vista, a whole new realm to explore, and that's the fascinating part of it. We only take cases in which other courts have disagreed. In India, the Supreme Court has to take every case, and they have a 50,000 case backlog or something. But we select only the cases in which other courts have disagreed. And so that's the fascinating part, is that you are on the frontier of the law, and what you write is the beginning of a frontier because there's new things to explore.
For those people that aren't familiar how you decide, let's go through the process. You have people who want to appeal to the Supreme Court. They have something called a writ of certiorari, and you accept about, you have to have 4 justices agree to accept
it's called the rule of 4. You need four justices to grant a petition for certiorari. Petition for certiorari is a motion to please take our case. And the court has thousands of petitions of certiorari each year. But they select only those cases where the courts are in conflict and where they think where we think the guidance of the court will be helpful.
When the cases are taken, the briefs are submitted by the lawyers. Do you talk to each other, the justices, before you actually hear oral arguments, or you just read the briefs and then you go to the oral argument and you don't talk to each other before you actually hear the oral argument?
We're very careful not to talk to each other before, in part just in fairness to the lawyers, and we don't want cliques where you and I agree or you and I disagree, and I don't tell you what I've talked to the other judge. We don't do that.
After you hear the oral arguments, you go back to a conference, and you have airtight room so nobody can listen to what you're saying, and so forth, and nobody is allowed in the room other than the justices.
Right. And we have a double door just to remind everybody that what goes on in there is absolutely private forever.
Right. So then you begin to say what your views are and who decides to speak first, who gets to speak first and who speaks last.
The Chief Justice speaks first. The next most senior justice, senior because he or she has been there the longest. Seniority is not by age, but how long you've been around. If you're the most junior, and it's 4-4, it's very exciting because everybody is listening to what you're going to say.
So who decides who writes the opinions? Who decides that?
Let's assume there's a majority and a dissent. Sometimes they're unanimous. There are a lot more unanimous opinions than most people think. The senior justice in the majority assigns the majority, and the senior justice in the dissent assigns the dissent.
Does any justice ever go down to another justice's chambers and say, you know what, I really don't like your opinion, but I'll support you if you support me on another case? Do you ever do that kind of horse trading?
No, that would be totally improper. Might even be illegal. You never trade votes, ever.
Nothing improper or illegal in Washington will happen, right?
Ever. So. Plus, we don't go to the other chambers. We send it by memo. But everybody gets a copy of that memo.
So the justices read the memos. They may change their mind and the opinions, but more times when you were on the court, you were the 5-4 in the majority than anybody else, I think.
I think that's right. Yeah.
So when you're 5-4 in the majority and you're making the real decisions because you're the deciding vote, does that put a special burden on you to really make sure you're comfortable with the decision?
You want the views of your other colleagues to indicate that you're going in the right direction or the wrong direction, and there's a lot of interchange in the memos that way, and that's how we try to put a majority together. Sometimes you're assigned a majority opinion, and you'll get a memo, "Dear Tony, I've read your draft opinion. it seems to me better to wait to read the dissent. You say, oh, what's going to go on? Or sometimes you write a dissent and say, you're on the other way around, you convince other people.
Let's talk about Bush v. Gore. You wrote the per curiam opinion, which meant that it's for the whole court. You didn't put your name on it. Was that a very difficult decision for the court to get involved in the case and then make the decision that would decide the election?
Not a difficult decision at all. 7 of us agreed with you to take it. Can you have a state court decide who's going to be the president of the United States and you say, well, we're too busy to take it? Gore bought the case, not Bush. Gore bought the case. And the rule is that if you're unsuccessful in the lower court and you come to the Supreme Court, you're the so-called petitioner and your name is first. So it was Bush who bought the case of the Supreme Court, so it was called Bush versus Gore. But Gore was the one who started the case. 7 of us agreed that we should take the case. And more than a majority, 6 or 7, agreed that there was a legal wrong. The question was how to remedy the legal wrong.
In that case,
and that was 5-4.
Ultimately, 5-4. The 5 people who were for Bush were Republican appointees. The 4 who were for Gore were the Democratic appointees. Some people said that showed the court was really political. How do you respond to that?
No, to begin with, that's wrong. Souter and Stevens were both Republican appointees.
Okay. All right. So you don't think the court was hurt by the perception that it was a political decision?
Yeah, the court's always hurt. It seems to me if we look political. One of my concerns, my present-day concerns, is there's too much partisanship. Presidents appoint justices from their same party. But the partisanship should not be an overriding factor. What you look at is temperament, learning, background, reputation, whether or not you have those qualities of independence and caution that make for a good judge. And the partisanship is overemphasized in the Senate during the nomination process. They should not emphasize it so much.
So you will be always remembered for, among other things, the decision you wrote to legalize gay marriage.
Yes.
And was that a difficult decision for you to come to? And have you found any reason why people are upset about that? Or do you think the court will ever reverse that decision?
Of course people were upset about it, and it was a very difficult decision. When we were growing up, the gay movement was just something we just didn't know much about or to think much about. With my clerks, we spent days researching the history of marriage, reading the Bible, and great works of jurisprudence in before the Christian era. For me, the important and perhaps deciding factor was the children. We were amazed to find that at first it looked like 75,000 children were adopted by gay parents, and then it turned out they were in the hundreds of thousands. And these children were in states that did not allow gay marriage at a disadvantage. If the child was sick, only the adopting parent, not the spouse, could come to see the child in the hospital. The kids would have to say they don't have to have two parents. The stigma and the hardship on the children was a very important factor for those of us in the majority.
You have been concerned about civility generally in life, and you think civil discourse is an important thing in our country. Increasingly, you see dissenting opinions in the Supreme Court aren't quite as civil as maybe you might prefer. And is that of concern to you? You're not on the court now, but is it a concern that sometimes the justices are very uncomplimentary of each other's views?
Yes, it's of great concern to me that our civil discourse, our civic discourse, is not civil enough. Aristotle said that a democracy depends on an open debate where you respect the dignity of those with whom you disagree. He said democracies only live if they are sustained over a period of time by a thoughtful, rational discourse. a discourse in which you respect the dignity of those with whom you disagree. And I think that's a danger in our present day and age. What do they call it? Political identity. If you're a member of party X, then we just assume you have all these views and we don't like you or we do like you. This is not good for our public and for our national discourse.
That's former Supreme Court Justice Anthony Kennedy in an extended conversation with David Rubenstein. You can hear the full conversation right now. It's episode 5 of the latest season of the David Rubenstein Show, Peer-to-Peer Conversations. Head to Bloomberg.com/peer-to-peer for more. Up next, we'll sample a little more of that conversation with Anthony Kennedy. I'm Nathan Hager, in for June Grasso, and you're listening to Bloomberg Law from Bloomberg Radio.
You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
I'm Nathan Hager, in for June Grasso on this edition of Bloomberg Law. June will be back next week. We've been focusing on the Supreme Court and listening in on a special conversation with former Supreme Court Justice Anthony Kennedy from his appearance on the David Rubenstein Show, Peer-to-Peer Conversations. Let's listen to more of Kennedy's conversation with David Rubenstein, recorded live on stage at the 92nd Street Y in Manhattan.
You have been concerned about civility generally in life, and you think civil discourse is an important thing in our country. Increasingly, you see dissenting opinions in the Supreme Court aren't quite as civil as maybe you might prefer. And is that of concern to you? You're not on the court now, but is it a concern that sometimes the justices are very uncomplimentary of each other's views?
Yes, it's of great concern to me that our civil discourse, our civic discourse, is not civil enough. Aristotle said that a democracy depends on an open debate where you respect the dignity of those with whom you disagree. He said democracies only live if they are sustained over a period of time by a thoughtful, rational discourse. A discourse in which you respect the dignity of those with whom you disagree. And I think that's a danger in our present day and age. What do they call it? Political identity. If you're a member of party X, then we just assume you have all these views and we don't like you or we do like you. This is not good for our public and for our national discourse.
You were born where?
Sacramento, California.
And your father was what, a lawyer?
My father was a solo practitioner and had an amazing law practice.
And your mother?
My mother had come to Sacramento. That's how she met him, from San Francisco, in order to work for the state government, and she had been a teacher as well.
What were your interests as a boy?
We were interested in our family in government. I learned to read at a very early age, reading classic literature when I was 8 or 9 years old. And so I was a little bored in school, and my parents thought it would be a good idea for me to be a page boy, the only page boy at the state senate.
You must have done pretty well in high school. You got into Stanford. Was it hard to get into Stanford those days, or not that hard?
It was hard to pay for it.
Stanford has a good law school. My son went to Stanford Law School. Why wasn't Stanford Law School the one you went to? Why did you just choose to go all the way to the east at Harvard Law School? And had you ever been to the east before?
If you had a list of we'll make it up, the 10 finest law professors in the country, 6 or 8 of them would have been at Harvard. It was simply amazing. Stanford was also very, very good. But
Harvard Law School has a lot of lawyers that come to Wall Street and do something important like practice corporate law on Wall Street. And how come you decided not to do that, to go back west?
It was important for me to go back home. Plus, my father was not well. It seemed to me important to help the family, and he wanted me at least begin even if I were practicing in San Francisco with a big firm. He wanted me to know what the structure of the legal profession was.
Where did you meet your wife, Mary?
Mary was also from Sacramento. Our families knew each other. Mary's younger, and so we didn't date in high school because the 3.5 years is a pretty big thing. But we knew each other.
You had 3 children.
And 9 grandchildren.
9. So you like the number 9, like on the court.
Right. Right.
The downside of being on the court is you can't talk to your wife ever about what you're doing?
No.
Okay.
Mary would never know what I was working on, what the case was, whether I was writing a majority or dissent. She didn't even know what the case was, and she'd read about it in the newspaper. She said, "Oh, you decided that case?" I said, "Well, yes."
So you're practicing in Sacramento, and then somebody gets elected governor of California, and he asks for some advice, and that person's name was Ronald Reagan. So
yes.
You got to know Ronald Reagan?
Yes. We first met before he was running for governor at some event in San Francisco. Reagan had some friends who were mutual friends, and we began to talk. And I said, "There's a few things you should never ask me." I said, "One is about politics." I said, "I know about it the way most people know about it, but so far as all the insider things that you have," and he had one of the best political teams ever assembled, and he didn't need any advice from me. So I said, "Don't ask me about politics." And I said, "Second, don't ever ask me who should be appointed a judge." And he said, "Oh, that's where you can really help." And I said, "Well, maybe so and maybe no, but if you get, as a lawyer," and I had small cases, but I would go in the counties around Sacramento to appear in court. And if you get the reputation as a judge maker or a judge breaker, it's not good. The judge is going to either lean over towards you or lean maybe against you to show that he's fair. And so I just didn't want that. So I said, "Don't ever ask me who should be appointed a judge."
Did you ever show him your Reagan imitation?
No, I don't think so. But he had a wonderful sense of humor, and he asked me. He wanted to have a state California ballot proposal, which would cut government spending, and so he asked me to draft the amendment. And I said, "Well, I don't know anything about budgets or bonds or special appropriations fund." He said, "Oh, this is an amendment to the Constitution, and you teach constitutional law." I said, no. That the constitutional law I teach has nothing to do with what you're talking about. He said, "You mean you can't write something that we're spending too much money?" Oh, I said, "Okay." So as it turned out, I told him that if he could, there were 2 or 3 very brilliant people that were acquaintances of mine. Pretty soon, Reagan got up and talked. He could absorb a briefing, David, better than any client I ever had.
He later called you and said Gerald Ford asked him for a recommendation to be on the Ninth Circuit Court of Appeals, and he recommended you, although you were only 38 years old.
Right.
You were confirmed easily, and then a couple years later, Reagan is president of the United States.
Yes.
Did you ever think he would be president of the United States when you first met him?
When his name started to surface, I thought, there is a possibility here.
Okay, all right. So he gets to be president of the United States. He has a vacancy on the Supreme Court, and he calls you to be considered for it, and you come in for the interview.
Yes.
He nominates you, and you get confirmed by 97-0.
Yes.
The last justice to be confirmed unanimously. So, okay. So you get on the court. This is, I think, the only time in the Supreme Court's history where you had the same 9 justices for 11 years. Yes. So you worked together with these same people for 11 years. Did you get tired of seeing them every day or not really?
Just the opposite. It would be, we were together so long, you knew what I knew, that you knew what I knew you were going to say, and we could more or less begin from there. And we knew sometimes we wanted to really work hard to convince each other, which we sometimes did in conference. You didn't always go into conference knowing exactly how the case should come out.
What would you like people to know about the court, and they might get by reading your book, that they might not already know?
They should know more precisely how collegial it really is. We know that if you and I are justices together, we know we would disagree. We're supposed to disagree. That's our job. But the question is how we disagree. The interaction on the court is much more fascinating than most people know. You hear things that you had not thought of before, and you see new possibilities for the law, because after you decide something, there's a whole new realm for which to explore the future. It was my privilege to serve with 17 different justices.
Your book is called Life, Law, and Liberty, and I enjoyed reading it, certainly, but I want to ask you a final question.
You stayed awake? Well, that's good.
It is said by some that if you see the word liberty in an opinion, you know it's written by Justice Kennedy. Why is liberty such an important thing to you?
When the authors of the Constitution sat down for a period of, 3 months in Philadelphia, if they had known all of the details of what freedom means, they would have put it down. But they were thoughtful enough to know that the components of freedom, the components of liberty, are something we must learn over time. So they use spacious words like life, liberty, and property. Incidentally, lawyers even sometimes make the mistake, we think of life, liberty, and happiness. That's the Declaration of Independence. The Constitution talks about life, liberty, and property. Why doesn't the Constitution talk about happiness? Because that's judicially unenforceable. Although perhaps some judges would be ready to try. But
you always carry a copy of the Constitution with you everywhere you go?
Well, usually I do. Because it's interesting. This is both the Constitution and the Declaration of Independence. If you read the Constitution of the United States, sit down cover to cover, it'll take you about 2.5 hours and you'll fall asleep for part of it. The preamble, the preface, is simply beautiful. But the Constitution, it's fascinating that it has lasted we have the 250th anniversary of the Declaration of Independence next year, and we're going to have a time capsule that people will open 250 years from now. If we put the Constitution of the United States in the time capsule 250 years from now, will it still be known? Will it still be respected? Will it still be the way in which our nation defines ourselves? It has been for the last 250 years.
That's retired Supreme Court Justice Anthony Kennedy speaking with David Rubenstein in a special conversation recorded live in October. You can check out their full conversation now on a recent episode of The David Rubenstein Show, Peer-to-Peer Conversations. Head over to Bloomberg.com/peer-to-peer to learn more. And that does it for this edition of Bloomberg Law. I'm Nathan Hager. June Grasso will be back next weekend. Thanks for listening and happy holidays. Stay with us. Today's top stories and global business headlines are coming up right now.